Good morning, everyone. This is a public deliberation being convened by the Baltimore County Board of Appeals on today, March 19th, 2024 at 9 a.m. It's in the matter of Milton Shaw and Jean Sobus, property located at 1306 Ivy Hill Road, and it is case number 23111-SPH, and it involved a petition for special hearing from Baltimore County Zoning Regulations, Section 500.7, to allow a 1.21 acre unimproved parcel to be buildable as a buildable lot, since the zoning for the parcel being RC4 and the minimum acreage requirement being 3 acres. And on August 7, 2023, there was an opinion and order of administrative law judge wherein the petition for the special hearing was denied. The matter was heard by this panel de novo on January 24th, 2024, and closing briefs were received on February 26, 2024. And so the main issue before us today is whether the petition for the special hearing for this 1.21 acre unimproved parcel zoned RC4 to be buildable as a lot, whether that should be granted. And what I'd like to do is I would like to hear from both of my co-panelists and what their position is and the rationale for that. And then I would like to present mine after I hear from my colleagues, because this one was a little more difficult for me. So I didn't know if Mr. Pennington or Mr. Lauer would like to go first.
Mr. Pennington, you want to go first? Yeah,
That's fine.
me too. I don't care.
Okay, Mr. Pennington.
So I think it boils down to the argument that Mr. Schmidt was making as whether this is a lot of record. So then we have to look back at when the lot was created, and I think everybody agrees. I think it's pretty clear when the lot was went from 22 plus whatever acres down to the 1 acre lot now. And then when the petitioners obtained the lot back in 1997, I believe, and what was the zoning back then. And I think it's pretty clear that the zoning then was RC5. So I know during the hearing, Mr. Richards testified, and I remember at one point I was just, I'm pretty sure I asked him, okay, when they purchased a lot back in 97, it was zoned RC5. Could they build on it then? I recall his testimony was yes, they could have. The zoning was subsequently changed as part of, I guess, the 2000 comprehensive zoning change to what it is now, RC4. Now, I mean, maybe you all can read the 1A03.4 of the zoning regulations better than I, but I don't see. I know it says, and I guess it's accepted that the minimum lot requirement is 3 acres now, but I can't find it. So I don't mean, and I think both parties agree that the way the zoning regulations are right now, it's a little confusing. Anyway, going back to the lot of record. So the questioning with Mr. Richards was that it was a lot of record, and they could build on it back then, so they shouldn't be penalized just because it's now. I mean, it stayed in the same hands. It's now 2024, and they could have built on it when they purchased it, so they should be able to build on it now. And I agree with that assessment. So, I mean, that's in a nutshell. That's where I'm. Obviously, there's some more deeper points, but that's in a nutshell where I am.
Yes, let me chime in here. First of all, I agree with you, Mr. Pennington, in where we are and where we need to go. I think it was a lot of record. I thought Mr. Schmidt's closing memorandum was very convincing. I felt that when he proffered the case, and I'll just say this for the record, it was a little harder for me to get the facts together as he proffered the case. And then he brought Mr. Richards up, and he brought some of the points in, but the memorandum cleared everything up for me. It really helped me clarify that. I do note that it was created, as you said, Mr. Pennington, in 1976 as part of that Oregon Ridge project, I guess. I think Judge Murphy may have not applied the correct section of the zoning regulations to this. I think as a lot of record, it basically meets the requirements of the RC 4. And, you know, in looking at a practical side of it also, which I always try to look, is what's the harm going to do if we approve this one way or the other? Is it really going to cause a real change in the neighborhood? I didn't see that. I didn't see that. I think most of the lots were similar in size. I think there was 3 or 4 of them listed in the memorandum or in my notes somewhere. So I don't think our approval would cause any significant harm to the neighbors. I do think you still got to go through the rest of the building process in terms of the distance from the stream, because that was somewhat debatable there, and other environmental things. But I think that those are set in place for the counties to protect the neighbors, and I think that will obviously have to happen. So that's kind of where I am. Would love to hear the chair's opinion on this also. Thank you.
Thank you both. I think based on the oral arguments, I thought I was going to have to go through a deeper analysis because, like you, Mr. Lauer, I was trying to follow the arguments, but the memoranda were very helpful, and especially that of Mr. Smith, as you mentioned. And I agree with both of you that this lot was grandfathered. It was a buildable lot. We have some issue around when it may or may not have been created, but whether we looked at 1976 or even at the time that the petitioners purchased it, it was Zone 5 at the time. And as Mr. Richards testified, when the property in 1976 was conveyed, Zone 5 had the 1 acre block or minimum requirement, so it met that requirement. So I agree with you there. And I was looking at the same, what would the harm be if they weren't able to build on that, and from the environmental perspective, I feel that the memorandum that Mr. Smith submitted satisfied that. We know that the department looked at those environmental issues, and of course they would have to, if they were to receive the permits, and make certain that they meet all those requirements, as you mentioned as well. So I don't see that it would have any harm to the area. And I was trying to see if there were other issues that were brought up that we may want to address in the decision. I guess I even went a step further, that if we had gone through these steps and we thought that they hadn't met the requirements, they had brought up the whole issue of, would it be an undue hardship, and if it would be some type of taking similar to the Krebs, and I felt that they would have met that that bar if we were to find that it was not compliant at the time of the conveyance. So I did give consideration for that as well. But I see that we all are in agreement, and of course we'll address all of the issues that were raised in the memoranda for the decision. And I do want to commend the parties on the work that they did, their presentation of their cases, as well as the memoranda that they provided. It was very professional and helpful. Well, thank you both.
All right,
And
well, thank you.
Thank you.
this concludes this hearing. Thank you.
Enjoy the rest of your morning, everyone.
You too. Bye-bye.